She almost lost her home and job to the company she worked for. She had worked for the same company for 11 years. The land beneath her feet had been hers for 23, and somehow, in the span of a single quarter, she nearly lost both. The plaintiff was a mid-level operations coordinator at a regional logistics firm she had joined straight out of college. By most accounts, she was dependable, private, and deeply attached to the half-acre property she had inherited from her mother in a quiet suburban township. The property sat adjacent to a large parcel owned by the very corporation she worked for, a national supply chain company that had been quietly expanding its regional footprint for the better part of a decade. The corporation, for its part, had revenues exceeding $4 billion annually. It employed thousands. It had a legal department that occupied an entire floor of its downtown headquarters. And in late March of what the court records identify only as Year 1, it hired a commercial surveying firm to assess the boundaries of its adjacent property ahead of a planned warehouse expansion. That survey would set everything in motion. According to the plaintiff, she first noticed the survey stakes in early April. Bright orange flags pushed into the soil roughly 14 feet inside what she had always understood to be her property line. She contacted the corporation's facilities department directly, assuming it was a clerical error. She was told someone would look into it. No one called back. When ground preparation crews arrived 6 weeks later with heavy equipment, she called again. This time, she was transferred twice before reaching a paralegal who informed her, calmly, that the corporation's survey confirmed the disputed strip fell within their recorded parcel. The plaintiff hired her own surveyor. His findings contradicted the corporation's by exactly 14 feet and 3 inches along the eastern boundary. She then filed suit, seeking $340,000, representing the assessed value of the disputed land, projected damages from the construction interference, and emotional distress she documented through medical records showing a significant spike in anxiety-related treatment during those months. Her attorney argued the corporation had used its institutional weight and her status as an employee to pressure her into silence. In a particularly striking moment during testimony, the plaintiff described a phone call she received from her direct supervisor, suggesting, gently but unmistakably, that pursuing the matter aggressively might create friction in her current role. The courtroom was quiet for several seconds after she said it. The corporation's defense was measured and technical. Their legal team presented the commission survey certified by a licensed firm with over 30 years of practice in the state. They argued the plaintiff's survey had used an outdated benchmark, a reference point that had been officially relocated and updated in county records nearly 8 years prior. Her surveyor, they claimed, had simply failed to account for it. The discrepancy wasn't misconduct, it was math. They also addressed the supervisor's phone call directly, characterizing it as a misinterpreted check-in from a manager concerned about a colleague's well-being during a stressful period. No written record of any coercion existed. The corporation's attorney reminded the court that good faith reliance on certified professional findings was not negligence. It was standard procedure, and they were persuasive. By the second day of proceedings, legal observers in the gallery were quietly suggesting the plaintiff's case was resting on shaky ground, quite literally. Then the township clerk's office produced a document no one had asked for. During a routine request for property records, the plaintiff's attorney had submitted a broad discovery poll. Among hundreds of scanned files, a single digitized document emerged. A boundary agreement signed 31 years earlier between the plaintiff's mother and the corporation's predecessor company. The agreement explicitly acknowledged a 14-foot vegetative buffer zone along the eastern edge, designated as belonging to the private residential parcel in perpetuity. The corporation's surveying firm had never been provided this document. Neither had their own legal team, it emerged. It had been sitting in an archived subsidiary file from an acquisition completed 19 years prior. The corporation's surveyor acknowledged, under renewed questioning, that the agreement would have materially changed his findings. The judge ruled in favor of the plaintiff. The disputed strip was legally confirmed as part of her property. The corporation was ordered to halt construction on the eastern boundary and restore the disturbed land to its prior condition. On the matter of damages, the judge awarded $218,500, declining the full emotional distress claim, but finding sufficient evidence of institutional pressure to include a damages component beyond the land's assessed value. The supervisor's phone call was cited specifically in the written opinion. The plaintiff retained her job, though she transferred to a different regional office within the year. The warehouse was built, slightly smaller, rerouted away from the boundary. The corporation did not appeal. The surveying firm quietly updated its intake procedures to require full historical title searches before certifying any boundary adjacent to a previously acquired property. The document had existed for 3 decades. It had survived an acquisition, a digitization project, and 11 years of the plaintiff walking past that property line every morning on her way to work. Which leaves one question worth sitting with. If she had never worked there, if she had been a stranger instead of a colleague, would anyone have ever thought to look?